I apologize for being the first to give an opinion on this matter, but being a former judge at the Andean Court of Justice, which has an harmonized legislation within the Andean community countries, I think I can speak a little bit about the experience in this matter. So first of all, I am fully aware that it creates problems, but at the end, I believe is a good thing to have. Nowadays, the IP issues are becoming, due to globalization, more and more common. Same problems, same perspectives, same issues, same companies, same lot of things. And because of that, I believe that a harmonized system is the best for judges, is the best for entrepreneurs, and is the best for consumers, because at the end, the decision-making process for all of them tend to be similar. So I believe that having harmonized laws, and in the particular case of the Andean community, a common regime that is much more than that, it creates a good route for IP. That's number one. And the second thing that I would like to raise is that harmonized system helps to create credibility within the framework of the constituencies. Put it this way, the Andean decisions are obligatory or mandatory for other countries. So at the end, investors and consumers and entrepreneurs at the end they know that within the Andean community, the rule of law will be exactly the same, that their companies will have the same situations and the approach will be the same. And also, from the side of judges, we are permanently enriching, and we are enriched by the approaches that our fellow judges in the Andean countries follow. So we enrich them by giving them our opinions, and they enrich us, telling us about our experiences. So at the end is a win-win situation. So because of being a former judge in an international tribunal that deals a lot with IP, I'm fully in favor of the harmonization. That's what I wanted to say at the very beginning. Thank you so much.
Can I add something?
Yes.
Because what Luis is talking about, then there's a big problem when he's talking about judge-made law, because in most of Europe we have the civil law system and not the common law system. And I also think we need to differentiate between what we're harmonizing, because in Europe most of the laws themselves are harmonized. So are we talking about the result that we want to have harmonization on? Because those are two different things. And in Europe, as I said, the laws are basically identical when it comes to trademarks. So it's the results that differ. And the Court of Justice in Europe has said time and time again that there is nothing strange about the results being different in country to country. And the problem is that we see, the European Union making different decisions to, for example, the biggest country in Europe, Germany, for example. So you have a trademark that is valid in the European Union as such as an EUTM, but which has been refused in Germany. So is it then valid in Germany at all? Or how do the holder of the trademarks proceed in such an instance? So that's where you need to differentiate between the law and the results when you talk about harmonization.
I agree with Elisabeth that for there to be harmonization, the law must be similar or identical, because judges cannot make laws. Judges have to interpret the law as laid down by Parliament. But looking at it from a small country's perspective, I fully appreciate that harmonization is good for a small country, because a small country is not likely to have so many cases in IP. So we will be able to look at precedents in other countries. Take the example of Singapore. Our law is based on the European directive. So our courts can refer to the decisions of the European Court of Justice, the English courts, to decide cases in Singapore. So in that sense, harmonization is good, but in my view, difficult to achieve in practice.
India is a very large country, and the major issue that we have is that while IP rights are territorial, yet due to rapid development of technology, the rights are exercised by the IP right owners on a global basis. Consequently, these IP rights are capable of being monetized internationally, and this necessitates harmonization. After all, one should not forget that the trademark owners are looking for consistency, they're looking for certainty, certain amount of predictability. Uniformity is a utopian dream, as it were, but certain basic principles, I think, will have to be harmonized. Certainly, one doesn't want to take away the freedom from the legislature to legislate. For instance, the TRIPS agreement has been very successful because the harmonization took place at a minimum standard level. It's not that they try to force their standards on all countries. They try to adopt the minimum common denominator, as it were. And it has worked very well over the period of time. And in a big country like ours, it's very difficult to get a legislation passed which will ensure harmonization. A small country may be able to pass laws with ease. But in our country, where there is a parliamentary democracy, where there are huge, or diverse groups which have different ways of looking at things, it's not that easy. Therefore, to one extent, I think the courts will also have to step in by looking at international decisions to fill in a vacuum. They will not act contrary to any law. They certainly cannot import any law which is contrary to their domestic law. But they can import the best principles if there is a vacuum in law.
I would also like to join this discussion and all the very interesting opinion. I really agree with what was said until now. And as you may imagine, in the European Union, we are also quite used to discuss the questions of the harmonization, as we have firstly the directive harmonizing the system or the regime of the member states, and then we have the regulation on trademarks, which is like the unitary level dealing with those trademarks which are then applicable all through the European Union. And I would agree on multiple points with what was discussed. Firstly, I think that the harmonization is really helpful, that even at the European level, it goes further and further. I mean, not only after the last legislative changes, change the directive, change the regulation, but also as a judge-made law, but still in the limits of the interpretation of what is already agreed on. But what is really helpful is having this kind of system. We can still make a lot of comparison of what is done by judges on national level. As Elisabeth said, for example, in Germany, there might be differences on absolute grounds, even on relative grounds, on opposition procedures. Sometimes it's due to the cultural or historical differences. You can have, therefore, a stricter aspect on the European level, because sometimes you have to stop for absolute grounds things which would pass in some member states without problems. So it's really a case-by-case basis. But after all, as to the big principles, I think we are still going further. And as Dedar mentioned, that Singapore is also analyzing sometimes European legislation, we are also surprisingly trying to get all the best from all around, be it from Singapore, India, Australia, US, and there is also this kind of international scope of the harmonization. I'm not meaning only TRIPS and the treaties themselves, but really, as in a globalized world, we have companies coming in front of the European Court of Justice, of the General Court, and they are in fact taking their knowledge to us. We have a lot of cases, for example, with companies coming from Australia, which are trying to give into work the principles which they do have domestically in application. And sometimes it's quite interesting to see, to compare with the jurisprudence or the case law which we have in Europe, be it on well-known and reputed trademarks and some others. So to make it short, I think that on the big principles, the trademark law can gain a lot in being harmonized globally.